Now, last week, President Donald Trump nominated Judge Brett Kavanaugh to the Supreme Court seat vacated by Justice Anthony Kennedy. The seat that, if he is approved, conceivably could be occupied by Judge Kavanaugh for 35 or 40 years. Our next guest has some reservations about him. David?
Bruce Fein is a constitutional scholar who was Associate Deputy Attorney General under President Ronald Reagan. Mr. Fein has been a visiting fellow for constitutional studies at the Heritage Foundation and an adjunct scholar at American Enterprise Institute. He has advised numerous countries on constitutional reform, including South Africa, Hungary, and Russia. He is also author of Constitutional Peril, The Life and Death Struggle for Our Constitution and Democracy, as well as American Empire Before the Fall. Welcome back to the Ralph Nader Radio Hour, Bruce Fein.
Thank you.
Thank you for coming on, Bruce. Most people hear the words, he worked in the Reagan administration, he had a stint at the Heritage Foundation. You're in for a big shock, listeners, because Bruce Fein is what I call a constitutional transcendentalist. That is, he doesn't play favorites. He doesn't have a rigid ideology that biases his conclusions. He basically reveals an enormous amount of knowledge about constitutional law. And we're going to talk about President Trump's nominee to the Supreme Court, Brett Kavanaugh, a circuit court judge in Washington, D.C. And just when he was nominated, Bruce, it turns out he teaches a course part-time at Harvard Law School since 2008. And the law school put out a very, very praiseworthy press release on him, saying how great he was at the law school with the students and so on and so forth. And no indication of the downside of Judge Kavanaugh, which is extremely fundamental. Take it from there, Bruce Fein.
Well, let me begin as background. I think most lay people don't understand that the Constitution is primarily a procedural document. Fair procedures is the cornerstone of civilization. Separation of powers, checks and balances. It's doing it according to the right process, with the right input, with the optimal way of diminishing the likelihood of tyranny. Indeed, the Constitution's separation of powers has been described as a structural Bill of Rights to protect the American people from tyranny, which is why the Supreme Court has held one branch cannot constitutionally give away its powers to another. For example, when Congress attempted to give line-item veto power to President Clinton, the Supreme Court said, no, you can't do that, because separation of powers, the cornerstone of our liberties, is something that's for the American people. It's not to vindicate the vanity of one branch's exercise of power. And what makes Mr. Kavanaugh's nomination, and I think this was true as Merrick Garland as well, is he, as well as Mr. Garland, and indeed most all of the recent appointees, are creatures of the executive branch. They've been trained, they've been steeped in the idea that the executive is smart and wise, and all power should be exercised by the executive, maybe begrudging Congress as little as possible. They serve in the executive branch. All the law schools, Ralph, as far back as you and me, all teach executive branch hegemony. There's virtually no focus on the Congress of the United States, its importance in checking executive excesses, which are ever present because of the incentive of the executive branch to concoct excuses for war or danger to aggrandize power. And we have not had a member on the United States Supreme Court with any legislative experience in the Congress for virtually a century. Hugo Black, who died in 1971, was the last person who served in the United States Congress as a senator, but he was appointed in 1937. So we have a court that over the last years, with rare exceptions, has continued to bow to executive branch supremacy. Most recently, I suppose, with the travel ban decision by 5-4, and before that, when Justice Kennedy wrote the opinion denying the right of Congress to have a role in foreign affairs and prescribing Israel as a place of birth in a visa, a passport for parents who had a child born in Jerusalem. So, no, the president has to decide that. The Congress has no authority whatsoever. And it's also troubling that despite the Supreme Court's decision, this one joined by Justice Kennedy, saying that detainees in Guantanamo Bay have a habeas corpus right to seek release based upon improper detention, that the Court of Appeals here in the District of Columbia Circuit, U.S. Court of Appeals, they have never once approved the release of a single Guantanamo Bay detainee since that decision called Boumediene almost 10 years ago.
That's the court that Judge Kavanaugh is
on, yes.
presently.
That is right. And one of the other judges who I worked for before he was appointed, Larry Silberman, once said, there's no way we will ever permit anyone at Guantanamo Bay to be released. And so if you look at Judge Kavanaugh's opinions, they're highly deferential to the executive branch, except, and remarkably, in regulatory cases where he backs away from his mentor, Justice Scalia's deference under the so-called Chevron doctrine, is more eager to second-guess what regulators would do, at least in the name of benefiting the regulated, typically big business, I would call the corporate capitalist, if you will, the crony capitalist. But I actually had a case, Ralph, before him. It concerned the immunity of a head of state from being sued under the Torture Victims Protection Act for cruelly decapitating those who happen to be Hindu in Sri Lanka. And the executive branch came in and said, well, we get to decide on our own whether you can sue a head of state. If it interferes with our foreign policy, we will instruct you as Article III judges how to decide the case.
This is under what president?
This was under President Obama. And the panel was Kavanaugh, it was Merrick Garland, and I forget who the third judge, and they wrote an opinion and said, that's right. Once the executive branch tells us to dismiss the case, that's what we have to do. I mean, it was truly remarkable. And also what's troublesome about the U.S. Court of Appeals here, upon which Mr. Kavanaugh sits, is they now routinely, in these terrorism cases, they issue opinions that are mostly redacted. Now, Ralph, you and I would have been stunned if we were studying constitutional law and we looked up at our case book, the Frein case book or the others, and found an opinion redacted. That's what now goes on customarily in the U.S. Court of Appeals here. And who decides on the redaction? The judges? No. They give the opinions to the Justice Department to redact the parts that justice says needs to be classified.
And this is an extraordinary example, listeners. Law students go to law school and they read appellate decisions. And until recently, you would never see a redaction unless it was a pornographic word, maybe. Yeah. And now you see it all the time. And the judges are basically letting the president, the executive branch, decide which phrases in their own opinions they get published, and for stare decisis, are going to be blacked out, are going to be redacted.
We have secret law. This goes back to Caligula, putting the laws so high no one could read them so he could snare them into violation. As a lawyer, how would you know? As lawyers know, you argue cases. You try to distinguish your case from someone else by focusing on the facts. Well, if the facts are all redacted, how do you even try to argue your case should be distinguished? You don't even know what it is.
Let's just look at the last 3 or so presidencies, and you can see that the executive branch has been engaging in secret wars, secret prisons, secret evidence, secret surveillance, secret appropriations, and just about everything contrary to open government, accountable government, in defiance of the Congress, which doesn't like to uphold its own duties on the Constitution and is quite happy, majority of them, in shoving it over to the White House. So what would a Judge Kavanaugh, how would he vote on this? How would he voted on the Iraq War, on the war on Libya, on drones going anywhere in the world? As a Supreme Court justice, would he defer to the president on all of these?
He would either defer or, the court characteristically in these situations concocts these excuses, political question doctrine, standing, justiciability, and just like they refuse to handle the political gerrymandering cases, they throw it out. They just dodge. I mean, the fact is, even when we had people, Harlan Fistone in World War II, they actually took on the Japanese concentration camp cases and ruled in favor of the executive branch. We have not had ever really a court during a time of crisis when there's an ongoing actual or fictitious warfare stood up to the executive branch, except when we did have members of Congress who sat on the Supreme Court. Hugo Black. Hugo Black, I mentioned, is the last member who was on the Supreme Court, wrote the majority opinion in Youngstown, Sheeton, 2 v. Sawyer. And he rebuked President Truman's seizure of the steel mills during the Korean War, despite Truman saying if there's strikes, we'll lack the steel to build our tanks and whatever. But it's notable that he actually had served in the Senate, so he understood the role of Congress. So, well, Congress can authorize this. It hasn't. If it's that important, you should be able to persuade a majority of the House and Senate. But I say we have these creatures, not only that they serve in the executive branch, but, Ralph, I underscore, the law schools teach the deification of the president. You go to law school, you understand nothing about the legislative process. You understand nothing about the checks and balances, the far greater transparency in Congress and the differences, because you have Republicans and Democrats, than what happens in the executive branch. When it's a unitary government, there's no dissent really permitted. All of it's secret, and so it's untested.
Bruce, tell the story of the national security aide to President Obama, Mr. Brennan, speech at the Harvard Law School.
Yeah.
What he said, how he was received, as an example of what you're pointing out. This was in 2011.
Right. And remember, John Brennan was, before he was appointed director of the Central Intelligence Agency, he was the deputy national security advisor. The reason why he was denied national security position is because even the Democrats and Republicans, they didn't think that he could escape the criticism because of his implication in the so-called torture techniques. We call them waterboarding or otherwise, techniques that both President Obama, who appointed him, and his Attorney General Eric Holder described as torture, namely a felony, an international crime that can be prosecuted anywhere. So this is the gentleman that travels and receives a motorcade-type applause as he enters Harvard Law School, probably coming up from Harvard Square, is my guess. And he delivers this speech. He's trying to explain how the rule of law prevails in the Obama administration in selecting people to be vaporized by predator drones. He says, well, we are really careful. We don't want to kill anybody who's innocent. So we just look at the really bad guys. And only if we decide somebody's imminent danger to the national security do we kill them. And imminence, however, doesn't really have the meaning that an ordinary person would think it has. It's going to happen immediately, soon. It can have a time frame as long as 1 or 2 years, like Mr. Awlaki being vaporized 2 years after he was put on the hit list in Yemen.
And
then they vaporized his teenage son at dinner in Yemen also, the teenage son also being at dinner. He was not involved in any belligerent or terrorism activity as well, but he was collateral damage, so to speak. And Mr. Brennan, he touts this as being celebratory of the rule of law. This is how the process works. The executive branch, on its own, without any outside review, decides whether somebody is an imminent danger to the United States. Now, do they tell you what components enter into that decision? No, because that's classified information. And based upon this untested, uncorroborated information, the president in secret decides whether to vaporize you with a predator drone. And that's called due process, he says, because we're really careful about who we kill. I mean, George Orwell couldn't even thought this stuff up in 1984, man. That's due process. I mean, it's the very definition of what James Madison described as tyranny. You're combining the executive, legislative, and judicial functions all in one particular, not only one branch, in one particular person.
In other words, the presidents are the prosecutors, the judges, the juries, the executioners, and the cover-uppers.
Yeah, you're right. And there's no questioning. You can't challenge the president. If you sue the president after the fact, like Mr. Awlaki's father, they say it's classified information. He goes into court and says, I want to know, on what basis did you decide? My son was a terrorist, a U.S. citizen was a terrorist. So the United States response is classified. We can't tell you. Dismiss, state secret.
It is a definition of tyranny that James Madison elaborated. It really is.
It is. It is.
Which is why they were very careful about giving Congress the exclusive war-declaring power, the exclusive appropriation power, among other powers, to try to make sure that we didn't get another tyrant like King George III. Our founding fathers are very, very clear about this. Well, back to Judge Brett Kavanaugh. Before he was a judge, in 1998, he wrote an article, a formal article, basically said that criminal investigations and prosecutions of the president should be deferred while he's in office. Congress should give back to the president the full power to act when he believes that a particular independent counsel is, quote, out to get him, unquote. So this has relevance today with the Mueller investigation. You think that was one reason that Donald Trump selected Judge Kavanaugh?
Well, if I thought Mr. Trump actually read, I think I would say yes. I don't think Donald Trump reads anything, Ralph. And plus, the nomination, note of him as well as Gorsuch, it's a little odd because he's picking from the so-called Ivy Leagues, and Trump's base is not Ivy League based. In fact, it's the opposite. Indeed, if you went to Yale Law School, where Mr. Kavanaugh graduated, or Harvard Law School, where he teaches now, I don't think you could find even one member of the faculty, maybe a handful of students, who would have voted for Mr. Trump. So, but I do think the people who were screening him, who really did the selection, was the Federalist Society. They are the ones who promote this idea, so-called unitary executive, and the exaltation of the presidency, in part because they get handsome jobs when the guy wins the presidency, is the one that would have looked at this particular law review article as favorable to Mr. Kavanaugh, because they do want an executive branch that's limitless in its exercise of power, because they want to be associated with an empire that rules the whole world. That's their mindset. And I do think that the law review article is quite concerning, because it does display a complete disregard of the idea that the executive, more than any other branch, needs to be checked. I mean, what president wouldn't automatically say, whatever independent counsel is investigating me is a burr in my thigh, and I'm going to fire them? I mean, Nixon would have fired Archibald Cox in 2 seconds. He ultimately did, but he would have fired Leon Jaworski as well. Bill Clinton would have fired Karen Starr, and we know Mr. Mueller had been fired long ago. I mean, it takes a naivete of staggering proportions not to recognize that any president who's investigated for criminal activity would conclude and publicly pronounce them as being a nemesis who's unfair and is out to get them. We don't permit just trust me. We do the Reagan trust but verify. And verification comes from having somebody independently do the investigation, which was how Watergate began. And that's not unique. We did Teapot Dome was with independent investigators, too, that were appointed by President Coolidge to investigate the Teapot Dome scandal that implicated executive branch officials. But what is really disturbing is that I believe the writing betrays this image of the president inflates his importance and preoccupation with serious matters of state beyond any recognition. I mean, he suggests that presidents are so wound up with the deliberative process and reading, philosophy and getting down to discovering facts and making these profound decisions that they have no time to respond to the allegations of wrongdoing. Now, that description is utterly and completely absurd. Now, Ralph, both you and I lived through the Nixon impeachment investigation that ultimately came to a conclusion when he resigned. But that was for about a year and a half. And we didn't find any fear that the United States government was going to fall or collapse because the president was spending time listening to tapes rather than worrying about the Italian lira or whatever. The government went on. This was a year and a half. It was true. That was both the Cox investigation as well as Sam Ervin. We both lived through the Clinton investigation. That ended up impeachment. There was a trial. Okay, we were able to survive. I don't know anybody said that there's certain work that was unfinished. We had unfinished symphonies all throughout these presidencies because they were subject to investigation, and in one case a resignation, another case impeachment. That's just silly. It's honoring the rule of law who defines us as a people. The government is not the be-all and end-all of what our prosperity is about. Our character as people, we comply voluntarily when we have the rule of law. And if we aren't strong enough to survive a president who is required, like other citizens, to respond to bona fide, credible investigations, then we are no longer a government of laws where due process matters. And at that point,
it looks like President Trump has picked someone out of central casting. Judge Brett Kavanaugh will very likely side with the executive and President Trump when the clash between the Mueller investigators and President Trump occurs, which can be right after Labor Day, and heads for the Supreme Court. So the key issue right now is the quality and the scope of the Senate confirmation hearing on Judge Brett Kavanaugh that's coming up. It's important for people who have something to say and have a record behind it to apply to testify before the Senate Judiciary Committee. Because, as you know, ever since the Bork hearings, the committee hearings have been very restrictive. They used to have critics on. Right now, what they do is first they have the praise from other members of Congress and from the executive branch. Then they have a couple panels, maybe of law professors, who talk in very technical terms, and that's it. And it's very short. We want days of hearings. He has a huge record to put before the public. He was deeply involved in the Bush machinations in the post-election date in 2000 in Florida. He was deeply involved in that so-called recount. He was deeply involved in the Ken Starr investigation of Clinton and was a prime author of the Starr report. He was deeply involved in the Bush-Cheney administration. So he's not just a judge where you look at his past decisions. So we want many days of hearings, and one way to increase the probabilities to have a lot of people who have a lot to say in one area after another about the propriety of him becoming a for-life judge on the Supreme Court, to ask Senator Grassley and the ranking minority, Senator Feinstein, to testify. And I hope you do that. Now, Bruce, about this time in the interview, I'm sure some of our listeners are saying, Mr. Fein, please tell us how this can be turned around, step by step. Who are going to be in the vanguard? Is it going to be the law schools? Is it going to be the law professors? Is it going to be grassroots effort back in the congressional district? If you were running this turnaround so that we have a real rule of law republic and a democratic society, and we treat people fairly, and we advocate peace and justice abroad, all of what you've written about in your books and articles and op-eds, how would you propose the turnaround start, and who would be in the vanguard?
Well, first, this is what the rules of the game are. They've changed since the Bork days, and we now have eliminated the filibuster for Supreme Court nominees. So he just needs 50 votes plus one, and the Vice President Pence could cast a deciding vote if there was a division. And at present, we've got 51 Republicans, 49 Democrats, but one of the Republicans, John McCain, is ailing and may not be able to cast a vote. And at least on the Republican side, it would seem the two most likely to be flipped would be Lisa Murkowski and Susan Collins. One is the former is from Alaska and the other from Maine, because they're worried about Kavanaugh's willingness to uphold the core holding of Roe versus Wade, the constitutional right to an abortion, subject to some limitations on regulation. And that's going to come about not by law professors, Ralph. It's got to come from constituents who write into their offices and say, we can't support you for re-election unless you vote no, because this nominee is not someone who's consistent with what we think is an impartial understanding of constitutional law.
That's true for every usurpation of our constitutional standards, right?
Yes,
whether it's war, peace,
right?
Whether it's
that's what they care about. Well, it is true, Ralph, but I do think that there's a hierarchy of violations. I mean, to my view, war stands at the apex of horrors, because war, the definition of war is it legalizes first-degree murder. You can kill people intentionally, not in self-defense. In any other circumstances, you or I did that, we'd be prosecuted for first-degree murder. And so it is the horror of horrors. It takes our brains and our collective genius from production to killing. We end up with a surveillance state, secrecy over transparency. It is truly, and that's where we're at. We're a perpetual warfare state. And we cannot survive as a republic unless this gets shifted around, because as long as the legal architecture, and we learn about that in law school, is war, the courts will never step in except on, occasionally, episodically, once every 10 years, and try to hold the hands and arrest the hands of the executive branch. We're lawless.
And when you add nuclear arms and a one-man trigger in the White House?
Yeah, it is. It's truly stunning. We have these proposals in Congress to say that the president needs congressional approval to use nukes. You don't need a statute. That's right in Article 1, Section 8, Clause 11. It would be like, Ralph, Congress introducing legislation to say you have free speech? It's been there for 228 years in the United States Constitution. So it shows the mentality up there is already one that conceives the executive branch as a virtual god. It's been a real counter-revolution. It's in our lifetimes alone, from a time where when we were alive, when they rebuked Harry Truman over Korea, to now where the president is deified and kill anybody on the globe on his say-so alone and not be accountable for it. We have, ironically, Ralph, been able to become the safest country in the history of the world. We spend more on defense than the next 20 countries combined. We've got the best Army, Navy, Air Force. We have oceans on both sides. We have more nuclear weapons, more than anybody else. Nuclear submarines, aircraft carriers, and yet we act as though we're about ready to be thrown into the sea by teenagers throwing rocks in Mali or Niger, and have military forces in 172 countries. And that's what the tyrants understand, that the human species is capable of being frightened at the drop of a feather if you put initial, inflammatory rhetoric out there. And we have to guard ourselves against being duped by these people. Yeah, there are real dangers, but we have to put them in context and proportion. And this is the most important thing we have to remember, I believe. The cornerstone of our republic, the cornerstone of due process and the rule of law. It's a moral principle. It's better to be risk being a victim of injustice than to be complicit in it. That one principle, better to risk being the victim of injustice than to be complicit in it, is what keeps our republic alive.
Well, on that note, we're running out of time. Thank you very much, Bruce Fein. And listeners, if you want to watch Bruce Fein testify for the Senate Judiciary Committee, just contact Senator Charles Grassley, U.S. Senate, Washington, D.C. It's easy to get his phone number, and tell him you want a variety of witnesses, including Bruce Fein, to testify on the nomination by President Trump of Judge Brett Kavanaugh to the Supreme Court of the United States. Thank you very much, Bruce.
Thank you, Ralph.